Good morning, Dr. Abante, and good morning, classmate. Welcome to MBA 305, Human Resource Management. My name is Ruth Peno Hermoso. Today, I will present the Part 10 of the HRM entitled Policy and Practice. In order to deal with HRM issues consistently, fairly, and thoroughly, the HR function is in charge of controlling practices. The implementation of both the letter and the spirit of employment law, the existence of information that informs HRM's choices, and the effective administration of HR affairs are all ensured by the system in place. The duties are carried out by the creation and management of the following. Number 1, HR policies. HR policies that set out the approaches used by the organization to deal with key aspects of HRM and provide guidelines to ensure the consistent application of these approaches. Number 2, we have the HR procedures. HR procedures that are formalized ways of dealing with specific employment matters such as discipline, redundancy, and grievance handling. Number 3, the HR information system. These are computer-based processes for managing the HRM and providing HR information, also known as EHRM. And number 4, we have the employment law, HR practice that meets employment law requirements. Okay, let's start with the Chapter 40, the HR policies. On contemplating this chapter, we should be able to define the key concept diversity and equal opportunities. We should also able to understand the following. Number 1, the reason for having HR policies. Number 2, overall HR policy. Number 3, specific HR policies. Number 4, formulating HR policies. And number 5, implementing HR policies. First question, why have HR policies? Okay. HR policies set out the approaches that the organization adopts to dealing with key aspects of HRM and provide continuing guidelines on how these approaches should be applied. They define the philosophies and values of the organization on how people should be treated, and from there are derived the principles upon which managers are expected to act when dealing with HR matters. HR policies should be distinguished from HR procedures. A policy provides generalized guidance on HR issues should be dealt with. A procedure spells out precisely what steps should be taken to deal with major employment issues such as grievances, discipline, capability, and redundancy. HR policies defines how the organization wants to handle key aspects of people management. As guidelines, the aim is to ensure that any HR issues are dealt with consistently in accordance with the values of organization and in line with certain defined principles. All organizations have HR policies. Some, however, exist implicitly as philosophy of management and an attitude to employees that is expressed in the way in which HR issues are handled. For example, the introduction of a new grade and pay structure. Although the benefits of consistency and clarity that come with clear regulation might seem evident, there are drawbacks as well. Written policies may be rigid, limiting, platitudinous, or any combination of three. The company can recover the policy easily. To disagree, or to a degree, policies have often to be expressed in abstract terms, and managers do not generally care for abstraction, but they do want to know where they stand. People like structures and formalized HR policies can provide the guidelines they need. Formalized HR policies can be used in induction, team leader, and management training to help participants understand the philosophies and values of organization and how they are expected to behave within that context. They are a means for defining the employment relationship and the psychological contract. HR policies can be expressed formally or overall statement of the values of the organization or in relation to specific areas such as discussed in this chapter. HR policies provide guidelines on how key aspects of people management should be handled. The aim is to ensure that any HR issues are dealt with consistently in accordance with the values of the organization and in line with certain defined principles. Next, let's move on the overall HR policies. The organization general HR policies outlines in attitudes toward its employment as well as how it fulfills its social obligations to them. It is an outward manifestation of its moral principles or view on how people ought to be treated. The value expressed in an overall statement of HR policies may explicitly or implicitly refer to the following concept. Number one, the equity. Treating people fairly and justly may adopt an even-handed approach. This includes protecting individuals from any unfair decision made by their managers, providing equal opportunities for employees or for employment and promotion, and operating an equitable payment system. For example, policies must be applicable to all regardless of tenure and position. Number two, we have the consideration. Taking account of individual circumstances when making decisions that affect the prospects, security, or self-respect of employees. And then we have the organizational learning. A belief in the need to promote the learning and development of all members of the organization by providing the process and support requirements. For example, in the appraisal uh, training or seminar attended for the period has points. And then we have the performance through people. The importance attached to the developing of performance culture and to continue improvement, the significance of performance management as a means of defining and agreeing mutual expectation, the provision of fair feedbacks to people on how well they are performing. For example, the immediate superior must discuss the appraisal result to the employee, why he or she is given such a grade for the period. Employee must have the chance to correct if there is misunderstanding. Next, we have the quality of working life. Consciously and continually aiming to improve the quality of working life, this involves increasing the sense of satisfaction that people obtain from their work. So far, the possible reducing monotony, increasing variety, autonomy, and responsibility, avoiding placing people under too much stress, providing for an acceptable balance between work and life outside work. There must be a work-life balance in every employee. And then, working conditions. providing healthy, safe, and so far as practicable, pleasant working condition. Do not put the health of the employee in danger, especially this time of pandemic. These values are espoused by many organizations in one form or another. The overall HR policies defines how the organization fulfills its social responsibilities for its employees and sets out its attitudes toward them. It is an expression of its values or beliefs about how people should be treated. Next, we move on specific HR policies. What are the most common areas in which specific policies exist? What are the most common areas in which specific HR policies exist? Number one, age and employment. The policy on age and employment should take into account the UK legislation on age discrimination and the following facts. Age is poor prediction of job performance. It is misleading to equate physical and mental ability with age. More of the population are living active, healthy lives as they get older. And then, the AIDS. An AIDS policy include the following points. The risk through infection in the workplace is negligible. Where the occupation does involve blood contact, as in hospital, doctors, surgeries, and laboratories, the special precautions advised by the Health and Safety Commission will be implemented. Employees who know that they are infected with AIDS will not be obliged to disclose the fact to the company, but if they do, it will be remain completely confidential. There will be no discrimination against anyone with or at risk of acquiring AIDS. Employees infected by HIV or suffering from AIDS will be treated no differently from anyone else suffering a severe illness. Next, we have the bullying. Bullying will not be tolerated by the organization, and that those who persist in bullying staff will be subject to disciplinary action, which could be severe in particularly bad cases. And then we have the discipline. The disciplinary policy should state that employees have the right to know what is expected of them and what could happen if they infringe to organization's rule. And then we have the diversity management. A policy on managing diversity recognizes that there are differences among employees and that these differences is properly managed will enable to work to be done more efficiently and effectively. It does not focus exclusively on issues of discrimination, but instead concentrate on recognizing the difference between people. Managing diversity is a concept that recognizes the benefits to gain from differences. It is not the same as equal opportunity, which aims to legislate against discrimination, assumes that people should be assimilated into the organization and often relies on affirmation action. A management of diversity policy could acknowledge culture and individual differences in the workplace. State that the organization values the different qualities that people bring to their jobs. Emphasize the needs to eliminate bias in such areas as selection, promotion, performance assessment, pay, and learning opportunities. Focus attention on individual differences rather than group differences. The policy can be strengthened by the development of diversity network. This acts as a support group for minority staff to share problems and swap tips, but they can accordingly help organizations to understand the people who work for them and help the business to perform better. For example, at Cisco, the Women's Network helps business development by hosting events for prospective and existing employee customers. At PwC, there are four main networks for women, ethnic minorities, disabled people, and GLEE, an inclusive business network for gays, lesbian, and everyone else. At TB, Disability Network focuses on awareness, raising about different disability to help managers understand them and get the best from people living with disability. Knowledge calls are provided, which consist of presentation done via conference calls and desktop technology with expert speakers on particular subjects such as Parkinson's and migraines. They typically include someone who has experienced the condition, a Q&A session, and inputs from HR relating to the condition of disability. There are outlined forums and subgroups offering support. Next common policies is the email and use of internet. The policy on emails could state that sending or downloading of offensive email is prohibited and that the senders or downloaders of such messages are subject to normal disciplinary procedure. The policy may also prohibit internet browsing, for example, of social networks or downloading materials not related to the business. Although this can be difficult to enforce, some companies have always believed that reasonable use of the telephone is acceptable and that policy may be extended to the internet. If it is decided that the employee's email should be monitored to check on excessive or unacceptable use, this should be included in an email policy, which would therefore be part of the contractual arrangement. The policy statement could be included to the effect that the company reserves the right to access and monitor all email messages created, sent, received, or stored on the company system. Next, we have the employment development. The employment development policy could express the organization's commitment to the continuous development of the skills and ability of employees in order to maximize their contribution and to give them the opportunity to enhance their skills, realize their potentials, advance their careers, and increase their employability, both within and outside the organization. The policy could also express the belief that age should not be a barrier to learning opportunities from which everyone can benefit irrespectively of how old they are. Next, we have the employee relation. The employee relations policy will set out the organization's approach to the right of employees to have their interests represented to management through trade unions, staff association, or some other form of representative system. It will also cover the basis of which the organization work with trade unions, example emphasizing that it should be regarded as a partnership. And then we have the employee voice. The employee voice policy should spell out the organization's belief in giving employees an opportunity to have a say in matters that affect them. It should define the mechanism for employees' voice, such as joint consultation and suggestion scheme. And then we have the employment relationship. Employment policy should be concerned with fundamental aspect of the employment relationship. They should take account of the requirements of relevant UK and European legislation. And then you have the equal opportunity. Equal opportunity policy should spell out the organization's determination to give equal opportunities to all, respectively of sex, sexual orientation, race, creed, disability, age, or marital status. The policy should also deal with the extent to which the organization wants to take affirmative action to redress an imbalance between the numbers of employed according to sex or race, or to difference if the level of qualification and skills are all achieved. Direct discrimination takes place when a person is treated less favorably than others are all would be treated in similar circumstances. Direct discrimination takes place when, whether intentional or not, a condition is applied that adversely affect a considerable proportion of people of one race, nationality, sex orientation, religion, or marital status, or those with disabilities or older people. The firm will ensure that equal opportunity principles are applied in all its HR policies and its particular to procedure relating to the recruitment, training, development, and promotion of its employees. Where appropriate and where permissible under the relevant legislation and codes of practice, employees of underrepresented group will given positive training and encouraged to achieve equal opportunity. And then we have grievances. The policy on grievances could state that employees have the right to raise their grievances with their manager, to be accompanied by the representative if they so wish, and to appeal to a higher level if they feel that their grievances has not been resolved satisfactorily. The policy should be supported by grievance procedure. And then we have the health and safety. Health and safety policies cover how organization intends to provide healthy and safe place and system at work. New technology. A new technology policy statement could state that there will be consultation about the introduction of new technology and the step that would be taken by the organization to minimize the risk of compulsory redundancy. A new technology policy statement could state that there will be consultation about the introduction of new technology and the steps that would be taken by the organization to minimize the risk of compulsory redundancy or adverse effects of other terms and conditions or working arrangement. Promotion. A promotion policy could state the organization's intention to promote from within whether this is appropriate as a means of satisfying its requirements for high quality staff. The policy could, however, recognize that there will be occasions when the organization's present and future needs can only be met by recruiting or recruitment from outside. The point could be made that a vigorous organization needs infusion of fresh bloods from time to time if it's not to stagnate. In addition, the policy must state that employee will be encouraged to apply for internally advertised jobs and will not be held back from promotion by their managers. However, reluctant the latter may be to lose them. The policy should define the approach that the organization adopts to engaging, promoting, and training all their employees. It should emphasize that the only criterion for selection or promotion should be ability to do the job. Redundancy. The aims of organization is to provide the employee security. It is the organization's intention to use its best endeavors to avoid involuntary redundancy through its redeployment and retaining program. However, if redundancy is unavoidable, those affected will be given fair and equitable treatment, the maximum amount of warning, and every help that can be provided to obtain sustainable alternative employment. The policy should be supported by redundancy procedure. Another HR policy is the rewards. The reward policy could cover such matter as providing an equitable pay system, equal pay for work of equal value, paying for performance, competence, skills, or contribution, sharing in the success of the organization, the relationships between levels of pay in the organization and market rates, the provision of employee benefits, including flexible benefits if appropriate, the importance attached to the non-financial rewards resulting from recognition, accomplishments, autonomy, and the opportunity to develop. Another HR policy is the sexual harassment. The sexual harassment policy should state that sexual harassment will not be tolerated. Employees subjected to sexual harassment will be given advice, support, and counseling as required. Every attempt will be made to resolve the problem informally with the person complained against. Assistance will be given to the employee to complain formally in informal discussion fail. A special process will be available for hearing complaints about sexual harassment. This will provide the employees to bring their complaints to someone of their own sex if they so wish. Complaints will be handled sensitively and with due respect for the right of both the complainants and the accused. Sexual harassment is regarded as gross misconduct and proof makes the individual liable for instant dismissal. Less severe penalties may be served for minor cases, but there will always be a warning that repetition will result in dismissal. Another HR policy is the substance abuse. A substance abuse policy could include assurance that employees identified as having substance abuse problem will be offered advice and help. Any reasonable absence from work necessary to receive treatment will be granted. An opportunity will be given to discuss the matter once it has become evidence of suspected that work performance is being affected by substance-related problems. The right to companies by a friend or employee representative in any such discussion. Agencies will be recommended to which the employees can go for help if necessary. Employment rights will be safeguarded during any reasonable period of treatment. Next is the whistleblowing. Explain that the organization believes that it is important to deal with any wrongdoings, especially those malpractices, especially sorry. Explain that the organization believes that it is important to deal with any wrongdoings, especially those malpractices, especially referred to in the Public Interest Disclosure Act 1998, including criminal offenses, risk to health and safety, failure to comply with a legal obligation, a miscarriage of justice, and environment damage. A specific example of unacceptable behavior could be given. Indicate that if any becomes aware of an issue that needs to be dealt with, they should raise the matter inside the organization, either with their line manager or if the allegation is about their line manager, to the more senior manager. State the employees will not be penalized for informing management about malpractice. And then we have the work-life balance. How the organization intends to allow employees greater flexible in their working pattern so that they can balance what they do at work with the responsibilities and interests they have outside work. To recap, uh, what are the most common areas in which specific HR policies existence, we have age and employment, AIDS, bullying, discipline, diversity management, emails and the internet, employee development, employee relationship, employee voice, the employment relationship, equal opportunity, grievances, health and safety, new technology, promotion, redundancy, reward, sexual harassment, substance abuse, whistleblowing, and work-life balance. Now let's move on formulating HR policy. The most important HR challenges in the organization need to be addressed through HR policies. External elements like regulations must also be considered. Managers, employees, and their representatives should be consulted as much as possible, and the policies and instruction for applying them should be widely disseminated. For the following steps should be taken when formulating HR policies. Gain understand of their corporate culture and its shared values. Analyze existing policies, written and unwritten. HR policy will exist in any organization even if they are implicit rather than expressed formally. Analyze external factors. Analyze external factors. HR policies are subject to the requirements of UK employment legislation, European Commission Employment Regulation, and the official code of practice issued by the bodies in the UK such as ACAS, the Commission for Equality and Human Rights, and the Health and Safety Executive. The codes of practice issued by relevant Professional institutions such as CIPD should also be consulted. Access any areas where new policies are needed or existing policies are inadequate. Check with managers, preferably starting at the top, on their views about HR policies and where they think they could be improved. Seek the view of employees about the HR policies. Seek the view of the union representatives. Analyze the information obtained in the first 7 steps and prepare draft policy. Consult, discuss, and agree policies with management and union representatives. Communicate the policies with guidance notes on their implementation as required. Now let's talk about the implementing HR policies. The aim will be to implement policies fairly and consistently. Line managers have an important role in doing this. It is they who will be largely responsible for policy implementation. Members of the HR function can be guidance, but it is line managers who are on the spot and have to take decision about people. The role of HR is to communicate and interpret the policies, convince line managers that they are necessary, and provide training and support that will equip managers to implement them. Now let's move on chapter 41, the HR procedures. HR procedures outline uh, the ways in which the management or particular manager should go about carrying out various actions involving people. They essentially provide a defined method of handling particular policy and practice issue. They should be separate from HR policies and operate as a standard for people. Management procedure may not always specific in details that action that should be followed in certain circumstances. More stringent procedures are used. They outline both that has to be done and how to do it. To ensure that HR policies are implemented consistently and in compliance with both legal obligation and ethical consideration, it is desirable to have the essential HR procedure documented. Everyone will be aware of the exact actions that must be done when handling any serious and potentially recurring employment difficulties if there is a written and widely publicized procedure in place. Employees and, if necessary, their representatives should be consulted prior to the introduction or development of HR procedures. Everyone must be briefed on the procedures and they should be made available either in an employee handbook or in a separate document. Line managers might require additional instruction on how to apply the procedures, and the HR department should offer assistance as needed. Normally, HR is in charge of making sure that protocols are routinely followed. As stated, procedures are necessary to handle capability and disciplinary issues, grievances, and redundancy. Now, what are the HR procedures? Number one, we have the capability procedure. There are some organizations that deal with capability issues through a disciplinary process, but there are many benefits to handling issues of low performance separately and saving the disciplinary process for situation of misconduct. Example of capability procedure. Example, yung policy. The company aims are to ensure the performance expectation and standards are defined. Performance is monitored and employees are given appropriate feedback, training, and support to meet this standard. Procedure. Number one, if a manager if a manager or team leader believes that the employee's performance is not up to the standard, an informal discussion will be held with the employee to try to establish the reason and to agree the action required to improve performance by employee or that manager's team leader. However, it is agreed that the established standards are not reasonable, attainable, they will be reviewed. It is established that the performance problems are related to employees' performance life, the necessary counseling or support will be provided. It is decided that the poor performance emanates from a change in the organization standard. Those standards will be explained to the employee and help will be offered to obtain conformity with the standards. It is apparent that the poor performance constitutes misconduct. The disciplinary procedure will be revoked. Number two, should the employee show no improvement over a defined period, let's say a week or a month, a formal interview will be arranged with the employee together with the representative if so desired. The aims of this interview will be to explain clearly the shortfall between the employee's performance and the required standards, identify the cause of unsatisfactory performance, and to determine what, if any, remedial treatment, training, or retraining support can be given. Obtain the employee's commitment to reaching the standards. Set a reasonable period for the employee to reach the standard and agree on monitoring systems during that period. Tell the employee that will happen. Tell the employee what will happen if the standard is not met. Then number three, the outcome of this interview will be recorded in writing and a copy will be given to the employee. At the end of the review, At the end of the review period, a further formal interview will be held, at which time, if the required improvement has been made, the employee will be told as this is encouraged to maintain the improvement. If some improvement has been made but the standard has not yet been met, the required period will be extended. If there has been no discernible improvement and performance is still well below an acceptable standard, this will be indicated to the employee and the consideration will be given to whether there are alternative vacancies that the employee would be competent to fill. If there are, the employee will be given the option to accepting such vacancy or being considered for dismissal. If such vacancies are available, the employee will be given full details of them in writing before being required to make a decision. In the absence of sustainable alternative work, the employee will be informed and invited to give his or her views on this before the final decision is taken. The employees may appeal against their dismissal. The appeal must be made within 3 working days. And then we have the disciplinary procedure. Disciplinary rules outline the steps that should be taken before taking any disciplinary action. Example of disciplinary procedure. It is the policy of the company that if the disciplinary action has to be taken against employee, it should be undertaken only in cases where good reason and clear evidence exists, be appropriate to the nature of the offense that has committed, be demonstrably fair and consistent, and previous action in similar circumstances. Take place only when employees are aware of the standards that are expected of them or the rules with which they are required to conform. Allow employees the right to be represented by a representative or colleagues during any formal proceedings. Allow employee the right to know exactly what charges are being made against them and to respond to those charges. Allow employees the right to appeal against any disciplinary action. For the disciplinary rules, the company is responsible for ensuring that up-to-date disciplinary rules are published and available to all employees. This will set out the circumstances in which an employee could be dismissed for gross misconduct. Procedure. The procedure is carried out in the following stages. First, a verbal warning or informal warning is given to the employee in which instance or instances of minor offenses. The warning is administered by the employee's immediate manager or team leader. And then, a formal warning or a written formal warning is given to the employee in the first instance or more serious offense or after repeated instances of minor offenses. The warning is administered by the employee's immediate manager or team leader. It states that the exact nature of the offense and indicate any future disciplinary action that will be taken against the employees if the offense is repeatedly within a specific time limit. A copy of a written warning is placed in the employee's personal record file but is destroyed 12 months after the date on which it was given. If the intervening service has been satisfactory, the employee is required to read and sign the formal warning and has the right to appeal to higher management if he or she thinks the warning is unjustified. The HR manager should be asked to advise the text of the written warning. And then, we have the further disciplinary action. If despite previous warnings, an employee will still fails to reach the required standard in a reasonable period of time, it may become necessary to consider further disciplinary action. The action taken by may be up to 3 days suspension without pay or dismissal. In either case, the department manager should discuss the matter with the HR manager before taking action. Step below the rank or departmental manager may only recommend disciplinary action to higher management, except when their manager is not present, for example, on night shift, when they may suspend the employee for up to 1 day depending on inquiry on the following day. Disciplinary action should not be confirmed until the appeal procedure has been carried out. And then we have the grievance procedure. The policy for handling grievances and the method of handling them are laid forth in a grievance procedure. Example of grievance procedure. Policy. It is the policy of the company that employees should be given a fair hearing by their immediate superior or immediate supervisor or manager concerning any grievances they may wish to raise. Have the right to appeal to a more senior manager against a decision made by their immediate superiors or supervisors or managers. Have the right to be accompanied by a fellow employee or their own choice when raising grievances or appealing against a decision. The aim of the procedure is to settle the grievances as nearly as possible to its point of origin. And then, the procedure. The main stage through which a grievance may be raised as the following. The employee raises the matters with his or her immediate manager or team leader and may be accompanied by a fellow employee of his own choice. If the employee is not satisfied with the decision, the employee requests a meeting with a member of management who is more senior than the manager or team leader who is initially heard the grievance. This meeting takes place within 5 working days of the request and is attended by the manager, HR manager, or business partner, the employee appealing against the decision, and, if desired, his or a representative. The HR manager records the results of the meeting in writing and issues copies to all concerned. If the employee is still not satisfied with the decision, he or she may appeal to the appropriate director. The meeting to hear the appeal is held within 5 working days of the request and is attended by the director, the head of HR, the employee making the appeal, and, if desired, his or her representative. The manager responsible for HR records the result of this meeting is writing and issues copy to all concerned. No further appeal can be made beyond this stage. Next, we have the redundancy procedure. When dealing with the difficult process, a redundancy procedure seeks to satisfy statutory, ethical, and practical factors. For example of redundancy procedure, redundancy is defined as the situation in which management decide that an employee or employees are surplus to requirements in particular occupation and not to be offered suitable alternative work. Employees may be surplus to requirements because changes in the economic circumstances of the company mean that fewer employees are required, or because changes in methods of working mean that a job no longer exists in its previous form. An employee who is given notice because he or she is unsuitable or inefficient is not regarded as redundant and would be dealt with in accordance with the usual disciplinary or capability procedure. What are the objectives? Number one, employees who may be affected by the discontinuance of their work are given fair and equitable treatment. The minimum disruption is caused to employee and the company. As far as possible, changes are effected with the understanding and agreement of the union and the employees concerned. Principles. The principles governing the procedure are as follows. The trade unions concerned with the information will be informed as soon as the possible of redundancy if foreseen. Every attempt will be made to absorb redundancy by the natural wage of employees. Find suitable alternative employment within the company for employees who might be affected and provide training if this is necessary. Give individuals reasonable warning of the pending redundancy in addition to a statutory period of notice. If alternative employment in the company is not available or more than one individual is affected, the factors to be taken into consideration is deciding who would should be made redundancy will be. Number one, length of service with the company, value to the company, other things being equal length of service should be determining factors. The company will make every endeavor to help employees find alternative work if that is necessary. Now let's proceed to HR information system. An HR information system or the HRIS is a computer-based information system for managing the administration of HR processes and procedures. EHRM is an alternative term for the use of computer technology with the HR function. Pari and Tyson defined an HRIS as a way of implementing HR strategies, policies, and practices in organization through a conscious and directed support and with the full use of web technology-based channel. They listed 5 goals for HRM. These are efficiency, service delivery, strategic orientation, manager empowerment, and standardization. Reason for introducing an HRIS. To improve quality of information available, to reduce administrative burden on the HR department, to improve speed which information is available, to improve flexibility of information to support business planning, to improve service to employees, to produce HR metrics, to aid human capital reporting, to improve productivity, to reduce operational costs, to manage people's working time from efficiently. The function of HRIS IS: absence recording and management, employee records, employee surveys, employee turnover analysis, e-learning, equal opportunity modeling, expenses, HR planning and forecasting, job evaluation, knowledge management, intranet, management diversity, manager and employee self-service, metrics and human capital reporting, online recruitment, online performance management system, and 360-degree feedback, payroll administration, pay reviews, pension and benefits administration. Most popular use of HRIS: absent management, training and development, rewards, managing delivery, recruitment and selection, other usually payroll, appraisal or performance management, HR planning, knowledge management, and expenses. Feature of HRIS. The feature of particular interest in an HRI system are the use of software integration with other IT systems in the organization, use of the internet, and provision of self-service. Use of the software: it is customary to buy software from an external supplier. There is a choice between buying a vanilla system without any upgrades, or customize the supplier system to meet a specified business requirement. Extensive customization can make future upgrades problematic and expensive, so it is important to limit it to what is absolutely necessary. If an external supplier is used, the choice should be made as follows. Research HR software market through trade exhibition and publication. Review HR processes and existing system. Produce a specification of system requirements. Send an invitation to tender the several suppliers. Invite suppliers to demonstrate their product. Obtain several references from existing customers, including site visits. Analyze and score the product against the specification. And then we have the alternative approaches. There are ways of providing IT service other than doing it by yourself. It is possible to choose cloud computing. Software as a service is an on-demand software delivery model in which users are charged for accessing and managing HRIT provision. And then the integration. Enterprise Resource Planning or the ERP system integrate all data and process of an organization into a unified system with the same database. HR systems are not frequently integrated to this extent, although they often link payroll administration with HR functions. Integration of the HR system with IT system in the wider organization so they can talk to one another will enable to more effective and efficient management of HR data. However, many HR functions retain standalone system because they believe integration would compromise their own system, potential lack of confidentiality, and the cost of perceived risk involvement. And then we have the internet. An internet system is one where computer terminals are linked so they can be shared information within an organization or within part of the organization. The scope of the organization that can be shared across terminals can be limited to preserve confidentiality, and this security can be enhanced by using passwords. HR intranet system can be used for purposes such as updating personal details, application for internal jobs, online requests for training, access to a e-learning, administration of inquiries or communication. And then we have the self-service. A human resource self-service system or HRSS allows the managers and employees access to information and the facility to interact with the system to input information or make choices of their own. This can operate through an HR portal. The steps are required are illustrated in Figure 42.1. The points to consider when introducing an HRIS. Make sure you really know what you need now and what you are likely to need in the near future so that you can give clearer guidelines to the software provider. Involve end users and other stakeholders in the decision making process. It is useful to include the member of the staff with IT expertise on the decision making team, even if they're not HR professionals. Go for something clear and straightforward that adds values. Don't go for all the bells and whistles. They may cost more, they take more time to administer, and you will probably end up not using anyway. Evaluate the range of systems on offer in terms of the how the reports and how easy and quick it is to produce the types of report you need. Look at how reports are presented. Can you download them in an Excel file, spreadsheet, or into Access so that you can manipulate the data yourself? How easy it is to do mail merge with information reported. When buying an off-the-shelf system, don't customize it unless it's critical. Each time the system is upgraded, this modification may cause you difficulties. If you do not if you do have modification, budget for this to be managed on ongoing basis. Now, let's go to chapter 43, the employment law. The employment relationship is subject to a great deal of regulation in all industrialized countries and is increasingly a feature of HRM. The purpose of employment law. There has been any grand strategy behind the construction of modern employment law. Instead, it has been built up steadily over 40 years, step by step. New laws being introduced is response to political pressure or one kind or another. Despite the lack of coherence in the development of employment law, it is not nonetheless possible to identify a number of key aims that government hopes to achieve by regulating the labor market. In 2013, the UK government issued a progress report on its program of employment regulation in which three distinct objectives were set out. Here, Minister stated that they sought the create of labor market that was flexible, encouraging job creation and making it easy for people to stay in the work and find work. Effective, enabling employers to manage staff productivity, and fair, employers competing on a level playing field and workers benefiting from the employment protection. The guiding principles in this situation is that it is forbidden to harm a worker, a job candidate, or a previous employee of the company. The phrase detriment is frequently used to refer to monetary loss, opportunity loss, or any serious harm to someone's feeling or dignity. The Equality Act of 2010 has now unified and some extent standardized most of the pertinent law, granting protection against discrimination to anyone who possesses certain protective characteristics. This includes uh, sex, sexual orientation, race, disability, religion or beliefs, pregnancy, marital status, and age. There are four headings under which an employer's action can be challenged in court. Number one, the direct discrimination. Example is failing to promote a woman because she is a woman. And then the indirect discrimination, requiring a devout employee to work on a holiday. Victimization, refusing to give a reference to a former employee who brought a race discrimination claim against the organization. And then harassment, teasing someone about their sexual orientation. Discrimination law. Former workers who have served for more than 2 years are eligible for file to claim to compensation or reinstatement if their dismissal was unreasonable. This is indicated were fired for arbitrary causes or for a legitimate one, such as misconduct, incapacity, or redundancy. And then we have the health and safety law. To prove negligence on the part of an employer or another employee is a requirement for the majority of Personal injury cases. Vicarious liability, which states that employers are held liable for their workers' activities while they are at work, is important to note in this situation. Therefore, the injured party files a lawsuit against the employers rather than the coworker whose carelessness resulted in the accident when it happens when it was in their fault. Hours and wages. Work hours and wages required are governed by number of laws. Family-friendly employment law. The major family-friendly rights that they applied in 2013 for most employees were as follows. Up to 1 year maternity or adopted leave. But in the Philippines, the maternity is up to 105 days only from the previous uh, 1 month maternity leave. And then we have the 9 months of maternity or adopted pay. The right to paid time off to attend antenatal appointments. 2 weeks is statutory maternal or paternal leave. Additional paternity leave after 32 weeks once a new mother has returned to work. The right to time off to deal with family emergencies. 18 weeks unpaid paternal leave during the time or during the first 5 years of the child's life. The right to request a change of contract in order to work more flexible. And then the whistleblowing law. Employee who makes a protected disclosure are shielded from unfair treatment or discrimination by Public Interest Disclosure Act of 1998. The instances covered include criminal offenses, danger to health and safety, non-compliance with a legal obligation, a miscarriage of justice, and environment damage. Enforcing employment law. Enforcement is mainly something employees do for themselves by bringing aims to the employment tribunal. However, if the field of health and safety, the government employs inspectors to carry out the main enforcement duties. And then the employment law NHRM. Published evidence demonstrate that employment law can have a majority impact on the way that employers carry out HRM activities. It consumes a great deal of HR professionals' time and in high on their agendas. A variety of good sources of free advice about the expectations of employment law and available managers. Thank you for listening. Thank you and keep safe.